Hey guys, what can you do if you have reasonable suspicion that a vehicle in a parking lot may be stolen, but you don't have probable cause? Can you still search the VIN if it's covered and run the car and so forth? Great question. My name is Anthony Bandiero. I'm an attorney and senior legal instructor for Blue to Gold Law Enforcement Training, bringing you another roadside chat. All right, this officer is from Littleton, Colorado. He said that he has a vehicle that is in a hotel parking lot, high crime area. They frequently, have gun calls, narcotics violations, recovering stolen vehicles. So your typical Motel 6. And while conducting patrol, he observes a vehicle in a parking lot that has no plates, is relatively clean in the interior. The VIN is intentionally covered. I don't know, what do you mean by intentionally covered? How would you know that? But, maybe this, I don't know, maybe, right? I don't know. Maybe something, I just don't know I would love to know how you know it's intentionally covered versus incidental. But so the officer says, am I legally justified in opening that car door to do or unlocking it to do a VIN inspection type deal or to run it? He says that New York versus Class and Rodriguez, some of these other cases don't really answer the question. They don't, right? Some people do believe though that Class it answers the question directly, but it actually says the opposite. In other words, a lot of cops think that Class would allow this, but it actually doesn't. Here's where we're at. Okay, so I don't think with these facts you have probable cause, right, that the car is stolen. If you did, then that means you could go to a judge and get a warrant and say, Your Honor, I believe based on these facts that the car is stolen. Do we really have that kind of confidence here? I don't think a judge is going to believe that you have PC, a fair probability this particular vehicle is stolen. We definitely know it's unregistered, right? We have, or at least we have PC for that, but we don't have PC that the vehicle is stolen, and that's going to be the problem here. And we're not allowed to do a search of a motor vehicle with reasonable suspicion alone. The only search that you can do of a motor vehicle with reasonable suspicion is for weapons if you have armed and dangerous during a traffic stop. The other thing is that it's not my interpretation that covering a VIN is in and of itself a crime in Colorado. You can disagree with me, but I don't think so, because tampering, obliterating a serial number and so forth is a felony in Colorado. And I just don't believe that if I'm at the valet and the valet ticket slides down and covers my VIN, that I'm now a felon in the state of Colorado. I believe you have to have intent to cover the VIN. I'm still not sure that's actually most states, I don't think that's still going to be a violation, but some states arguably covering the VIN could be a violation, but in most states it's going to require something with the VIN itself, like, scratching it out, switching it out, being a clone car and so forth. Okay, so I don't see it. What other facts do you have that this car is stolen, right? Punch ignition. It's what else could be here? You have this make and model is on a hot sheet from a car that got stolen, a week prior. Things like that would help, but without that, I don't think we're gonna be able to search the car. So here, what I would do in Class, by the way, let's address Class. So Class is that case where the officer had a traffic stop in Class, and Class was the driver. Okay, he wasn't making traffic stops while in Class. He was paying attention like you should be, but he noticed that the VIN was covered, so he opened up Class's door to go do a inspection on the placard or to move the VIN cover or the thing that covered the VIN, and he saw like a firearm in plain view. Well, the U.S. Supreme Court upheld that because they said that's kind of like pretty much part of the traffic stop. There's no inherent privacy in the VIN itself, highly regulated vehicle and so forth. But the point is that they also stated there that essentially the cops couldn't just do routine VIN inspections just because, right? You would have to have a lawful traffic stop or some kind of lawful encounter with that vehicle first in order to kind of justify running that, seeing that VIN, moving the piece of paper and so forth. So that's where we're at here. At the end of the day, they're going to need probable cause. So maybe sit on it, wait for it to move, or talk to the motel manager, find out whose car it is, see if they'll abandon a car, right? Ask these people, hey, do you have anything to do with that car down there? Oh, no, we don't. I don't know whose car that is, but you know for a fact from the manager that they, drove that car in there. You can have abandonment if you feel good about that. But the point is that you're gonna need something more than just reasonable suspicion, which you certainly have here, but you don't have probable cause in my view. All right, you're close, but no cigar. So keep the questions coming. If you like what we're doing around here, like, subscribe, share with your friends. We're a small niche channel. All we do is try to make case law, explain case law to cops. And if you like what we're doing here, again, that really helps us. All right. Until next time, my friends, stay safe and make good case law.